and welcome to Verdictum. I am Ananya Singh and you're watching today's legal news, where we apprise you with the recent important legal developments across the country. Let's take a look at the headlines. Supreme Court overrules NN Global verdict, upholds validity of arbitration clauses in unstamped agreements. CJI to take a call on listing of Mahua Moitra's expulsion challenge, says Supreme Court. Punjab and Haryana High Court orders police protection for businessman, alleging threats from MP Kirron Kher. Ashneer Gover moves NCLT against BharatPe, alleging oppression and mismanagement. Government decides to retain provisions bringing CEC and other election commissioners at par with Supreme Court judges. Now the headlines in detail. In a landmark decision today, a 7-judge constitution bench of the Supreme Court, comprising the Chief Justice of India D.Y. Chandrachud, along with Justice S.K. Kaul, Justice Sanjeev Khanna, Justice B.R. Gavai, Justice Suryakant, Justice J.B. Pardiwala and Justice Manoj Mishra, held that arbitration clauses in unstamped arbitration agreements are valid and enforceable. However, such agreements cannot be admissible in evidence. The court sat for reconsideration of the correctness of the NN Global case, which with a 3-2 majority ruled that an agreement which is not sufficiently stamped cannot be said to be an enforceable contract as per Section 2H of the Contract Act. The matter came to be referred to a larger bench of 7 judges on September 26th by the Supreme Court's 5-judge constitution bench. The 5-judge constitution bench headed by the Chief Justice of India D.Y. Chandrachud observed that the issue has caused limitless uncertainty in the area of arbitration law and had to be considered by a larger bench. The present plea is a curative petition challenging the judgment dated February 14, 2020. The Apex Court today, while overturning its previous verdict, held that unstamped or insufficiently stamped agreements are inadmissible under the Stamp Act, but are not void ab initio, and such a defect is curable in nature. The court further said that the concerned court may only examine if an arbitration agreement prima facie exists, and that the interpretation according to the Stamp Act does not allow law to be flouted, and it ensures that Arbitration Act does not detract from Stamp Act. The Supreme Court today said that the Chief Justice of India D.Y. Chandrachud will take a call on urgent listing of Trinamool Congress leader Mahua Moitra's plea, challenging her expulsion from the Lok Sabha. The matter was expeditiously mentioned before a bench consisting of Justice Sanjay Kishan Kaul and Justice Sudhanshu Dhulia by senior advocate Abhishek Manu Singhvi, who pressed for urgent consideration of the matter. Responding to this, Justice Kaul conveyed to the counsel that the CJI has been entrusted with the responsibility to decide upon the listing. Moitra approached the Apex Court contesting her expulsion on December 8th, following the adoption of a report by the Ethics Committee that found her guilty of accepting bribes to ask questions in the Parliament. Moitra allegedly accepted gifts and illegal gratification from a businessman, purportedly to advance his interests. Moitra expressed strong disapproval of her expulsion, calling the parliamentary proceedings kangaroo court. She also accused the government of weaponizing the parliamentary panel to coerce the opposition into submission. The Punjab and Haryana High Court has directed the Chandigarh police to provide protection to businessman Chaitanya Agarwal and his family members for a week. This decision comes in response to a petition filed by Agarwal, alleging threats from BJP leader and MP Kirron Kher and her aide Sehdev Salaria. Agarwal, represented by senior advocate Anmol Ratan Sidhu, expressed concerns for his and his family's safety in his petition. According to the petition, Agarwal alleges establishment of contact with Salaria, who is a close aide of Kher, through a BJP worker. He claims to have received 8 crore rupees from Kher for investment, of which 2 crores have been returned, and the remaining 6 crores is pending. Agarwal states that due to market fluctuations, he sought more time to generate profits from the investment made by Kher and to return the money. But he claims to have been faced with immediate threats to return the money and experienced constant harassment by Kher and Salaria. The public prosecutor in the case, Manish Bansal, informed the court that no official complaint has been lodged by the petitioner in any police station regarding alleged threats. He also noted the absence of any calls to 112, the helpline designated for reporting such matters. The High Court, in its order, refrained from commenting on the merits of the case or the admissibility of the allegations. Nevertheless, it directed the Superintendent of Police and the SHO to provide protection to the petitioner for a period of 1 week. The court also said that in case the petitioner no longer requires such protection, it can be discontinued in less than a week. The court also directed the petitioner and his family not to leave their residence other than for basic medical needs or necessities. In a recent development, Ashneer Gover, the former co-founder and managing director of BharatPe, has approached the National Company Law Tribunal against the fintech major. Gover has filed a plea invoking sections 241 and 242 of the Companies Act of 2013, alleging oppression and mismanagement within the company. The present move follows a series of events, including a fine imposed by the Delhi High Court on Gover in response to alleged defamatory posts on social media against BharatPe. Despite Gover tendering an apology, the court proceeded to levy a fine on Gover, emphasizing such actions cannot be taken for granted. Earlier, directions were also issued to both parties, Gover and BharatPe officials, to not engage in defamatory and unparliamentary language against one another. BharatPe previously initiated defamation proceedings against Gover, claiming Rs 88.67 crore in damages for alleged cheating and misappropriation of funds by Gover, his wife Madhuri, and his brother. In response to vehement protests from opposition parties and former chief election commissioners, the government has decided to maintain the status of the chief election commissioner and other election commissioners at par with the judges of the Supreme Court. The move comes in wake of the introduction of the Chief Election Commissioner's Appointment, Conditions of Service and Term of Office Bill of 2023 in the Rajya Sabha in August. The bill initially proposed aligning the status of CEC and ECs with that of the Cabinet Secretary. However, it was opposed by the opposition parties and former CECs for compromising the independence of the institution. The government then introduced amendments to the bill, including one notable amendment which stipulates that the CEC and other commissioners shall be paid a salary equal to that of Supreme Court judges. Another significant change involves upgrading the search committee by replacing the Cabinet Secretary with the Law Minister as its head. Additionally, the amendment seeks to insert a new clause seeking to safeguard CEC and ECs from court proceedings while carrying out official duties. The amendments further address concerns about the removal of CEC and ECs. The clarifications come in line with the constitutional provisions under Article 324 dealing with the Election Commission. That was all on today's legal news. Thank you and keep watching Verdictum. And subscribe to our channel and download the Verdictum app on iOS and Android to keep yourself updated with authentic legal news.